Either through legislation or regulation, there is a likelihood that we will face a carbon-constrained future here in the U.S. regarding our emissions. And either way, the EPA would face complex new mandates under those systems. Joining me now to discuss the prospects is Richard Stoll. He is an environmental and administrative attorney with Foley Lardner here in Washington. He's worked in the EPA's Office of Counsel General, and also he's the former chair of the ABA's section of Environment, Energy, and Resources. Dick, great to have you with us today.
Tyler, glad to be here.
Deep breath after all those titles. The reason I wanted to talk to you today is because of your recent article for the BNA Environment Reporter. You analyzed the Waxman-Markey Act in the House, which has passed through and the Senate will take up at some point, regarding the impact on the EPA, and it is substantial under this potential legislation.
Very much so. There's 5 titles to the act, but the main title, which is called the Safe Climate Act, it has its own name for that title, would impose massive duties on EPA for the next couple of years once this becomes law, if it becomes law.
You had said, I'm quoting now, an amazing number of brand new regulations with tight statutory deadlines that can become enforceable in federal court would be imposed under this legislation.
That's right, Tyler. And this is following a model that's been used in other environmental legislation over the last 20 or 30 years, but it's a little more intense, I must tell you that. But generally under the Clean Air Act, the Clean Water and so forth, those statutes have mandated that EPA issue regulations within so many months or within so many years. Now this is really coming in with this new statute. If it becomes law, it's going to be a very intense exercise of those same types of duties.
And you had said, Dick, there are some very specific deadlines here, something like 31 new regulations for the EPA, all within specified deadlines here.
Yep. EPA actually would have to do a lot more than 31 new regulations under this law, but the ones with statutory deadlines, there are 31 of those, and they're almost all within 18 months or 24 months of enactment. So it would keep EPA awfully busy, and you have to wonder whether they would meet the deadlines. But that's the regime that's been set up by Waxman-Markey.
Well, given your time inside of the agency itself, what does that mean in terms of the workload that the EPA has right now, as well as what it could face?
What you see is that the rulemaking process is taking much longer to do now than it used to take. There's many more hurdles that the agency has to go through. So it's very resource intensive. Many offices within the agency have to work on a rule. Many people get involved. People are commenting on the rules from the outside. Now the rules have to go through OMB and so forth. So compared to when I was there, when sometimes we could get a proposed rule ready to go to the Federal Register after just a few weeks of drafting and get it in the Federal Register. Now it takes years, and it takes months and often years to do that, just that same process. And to go from proposed to final then takes another year or two sometimes.
And you cited a recent GAO report regarding the average time for an agency to complete a significant regulation.
Yes.
A little more than 4 years for the average agency, if there is such a thing. But you pointed out that the EPA average is roughly 5.5 years, and those numbers can vary greatly depending on what it is.
Yeah, and also note in that same report that the GAO said, particularly for complex areas which are new to the regulatory framework, that the period can be even longer. You got to understand that most of the subject matters that would be dealt with in the Waxman-Markey bill, where EPA would have to go through rulemaking, are very complex and areas that EPA has not regulated before, like carbon sequestration, deforestation. Those are areas that have not generally been subject to regulation in the United States.
And you also pointed out nothing in this bill relieves the EPA of any of its usual procedural obligations. In fact, when you get into the Clean Air Act, which is so complex, it actually goes beyond the standard rulemaking process.
It does. The standard rulemaking process, for instance, doesn't require public hearings. The Clean Air Act does. So that's just one more layer. Even the standard rulemaking process these days imposes just massive work on an agency. But the Clean Air Act imposes even a little bit more, and nothing in Waxman-Markey takes that away.
Another interesting aspect here, Dick, is the fact that invariably there will be lawsuits, if whether it's legislation or regulation.
Right.
But within Waxman-Markey, you point out that the new EPA regulations remain in force even if a federal appellate court challenges them and rules against them.
Well, it gives the courts the discretion to give that result. It doesn't mandate that they remain in force, but it explicitly gives courts the discretion to decide, even though the court is holding a rule invalid for whatever reason, it gives the court the discretion to go ahead and leave it in place while EPA goes back and reworks it. That's quite different than the normal Administrative Procedure Act provision, which basically says if a court finds a rule invalid, it shall vacate the rule. So the Waxman-Markey would turn that around.
Bottom line now, if we are talking about implementation in 2012, what about the job at hand for the EPA and when it's feasible to turn around so many of these mandates?
Even assuming they would meet their statutory deadlines, which seems unlikely because they almost never do anyway, and these are too tight, then there's going to be judicial review, which is provided for. It's always been provided for, and it's also provided for in this law. There'll be judicial review of the regulations. That usually holds things up for a year or two longer. So I wouldn't look to see much of this being implemented on the time frames that are set forth in the statute. I just don't think it's going to happen.
All right. The article is in the B&A Environment Reporter. Dick Stoll is Environmental and Administrative Attorney with Foley and Lardner here in Washington. Dick, thanks so much for joining us today.
Thank you, Tyler.